I'm Shahid Sulaiman from the Corporate Department of Bowman Gilfillan. I'm going to chat about Islamic finance. In its simplest sense, Islamic finance relates to the development of financial products that comply with the requirements of Islamic law. Now, the scholars of Islamic law have identified a number of issues which they regard as being important for the structuring of financial products and which would affect the acceptability of those products from the perspective of Islamic law. The factor which comes into play most frequently is the requirement that financial products be structured in a manner that excludes interest. Now, in general terms, Islamic law prohibits the charging of interest, whether it is an essential feature of the product in question, such as in the case of an interest-bearing loan, or whether interest is incidental, such as an agreement which is otherwise in compliance with the requirements of Islamic law, but which provides for interest to be charged on default in making payment. So whether the interest is incidental, whether it is intrinsic to the transaction, the presence of interest in a financial product would render that product prohibited from the perspective of Islamic law. An interesting point that should be kept in mind is that the common view that Islamic law prohibits a return on the advance of money is, strictly speaking, correct. Islamic law, in fact, permits a return, provided that the return is structured in such a manner that it would not be regarded as interest from the perspective of Islamic law. With that in mind, Islamic scholars have devised a number of mechanisms which are believed to comply with that requirement. In other words, these mechanisms provide for a return to be provided on the advance of capital, but the structure of that return is such that it would not constitute interest. In addition to the prohibition of interest, we find that Islamic law would prohibit any investment activity that relates to something which is prohibited in Islamic law. So, for example, Islamic law prohibits gambling and liquor. Any financial product or investment product which involves an activity such as gambling or liquor or any other prohibited activity for that matter would not comply with the requirements of Islamic law. So in structuring investment products in particular, it is important to ensure that the investment activity does not involve any activity which would be prohibited by Islamic law. In addition to these prohibitions, Islamic law would also prohibit transactions that have an excessive amount of uncertainty, and similarly, Islamic law would prohibit transactions where the performance of any of the parties is contingent on an uncertain future event. Let us move on to some of the common structures which one encounters in the context of Islamic finance. There is a structure that is known as the murabaha structure, which is effectively a resale at a profit. The structure is commonly used in the financing of assets, commodity finance and the like. And what it involves is that the funding party, namely the bank, would actually purchase the asset that the client wants to acquire. The bank would then on-sell that asset to its client at a markup, and the purchase price on the resale would be paid over a period of time by way of installments. Those installments would reflect the marked up price charged by the bank to its client. Another structure that one commonly encounters is the ijara structure. The ijara structure, very simply, is a form of lease structure. In this structure, we find that the funding entity, usually the bank, would purchase the asset and would then rent that asset to its client at a market-related rental. In addition to the market-related rental, there would be a certain amount that reflects payments of capital in a more conventional transaction. And at the end of the lease period, the client would be entitled to take ownership of the asset. And there are various mechanisms in terms of Islamic law that would give effect to that transfer of ownership. Thirdly, we have a structure called the mudaraba structure. And the mudaraba structure, very simply, is a form of silent partnership. It's a form of equity arrangement in terms of which the funder would provide capital to an entrepreneur. The entrepreneur would then proceed and engage in whatever business activities has been agreed upon between the parties. At the end of the day, when a profit accrues to those business operations, the funding entity and its client, the entrepreneur, would then share in the profits in accordance with an agreed profit-sharing ratio. In practice, we find that structuring of Islamic financial products is not as simple as merely putting together a structure that complies with the skeleton framework provided by Islamic law. We find in practice there are very real challenges which do arise. One of these challenges is the fact that in practice it is very difficult to exclude income or investment activity that relate to or come from a source which is prohibited in terms of Islamic law. So very often we find that investment funds cannot exclude interest income from accruing in all circumstances. So inadvertently one finds that in investment funds there is a certain amount of prohibited income which accrues to the fund. Now the operators of these funds have developed mechanisms to identify the prohibited income which accrues, and secondly, to dispose of that prohibited income in a manner which complies, of course, with Islamic law once again. Another problem encountered in practice is that in murabaha structures, and I suppose to a certain extent in ijara structures as well, where two transfers of ownership takes place. First of all, the acquisition of ownership by the funding party, and secondly, the acquisition of ownership by the client of the funding party at a later stage in the transaction. In certain circumstances where a levy is charged on transfers of ownership, we find that the costs of the transaction are increased since a double levy accordingly accrues. So if we look at the property transfer, for example, if the murabaha structure is used to fund a property acquisition, the bank would purchase that property and the bank would then on-sell that property to its client at a profit. But when the bank purchases that property, that is an acquisition of ownership which triggers an obligation to pay transfer duty. When the client in turn acquires that property from the bank, a further amount of transfer duty is triggered and the cost of the transaction is effectively doubled. In practice, it could actually be increased by more than simply double. Now, there are various mechanisms that are utilized to avoid or to minimize the risk of double transfer duty, and careful structuring is required to ensure that these mechanisms actually work. In certain jurisdictions, incidentally, such as England, the law has been changed to allow for murabaha transactions to take place without double transfer duty being levied. In practice, we also find that the structuring and the operation of Islamic financial products is heavily dependent on the existence of an Islamic supervisory council. The function of this council is to, first of all, certify that the product has indeed been structured in a manner that complies with Islamic law, and secondly, that supervisory council will play an important role in ensuring that the ongoing operations of that structure continue to be in accordance with Islamic law. In practice, we'll also find that if any issue arises with respect to the operation of that product, the operators of the product or the people who manage that product would approach the supervisory council for a verdict as to whether that issue presents any problems from the perspective of Islamic law. The final practical issue that I'd like to touch on is the question of properly documenting Islamic financial products in a manner that would comply with the relevant regulatory framework as a starting point, and secondly, in a manner that gives effect to the requirements of Islamic law. We sometimes find that the only aspect of a product which complies with Islamic law is the marketing material. If one delves a bit deeper to the actual documentation, the legal documents related to that structure, we find that the requirements of Islamic law do not in fact have any existence. Let us conclude. With companies in South Africa at the moment making overtures to expand in the rest of Africa and also in the rest of the world, we find that invariably they do encounter communities or societies where there is a large Muslim component. Companies that are able to develop structures that address the cultural and religious needs of these communities will, of course, find that they enjoy a competitive advantage as compared to their competitors who have not prepared themselves accordingly.